Have you ever moved out of a rented house only for your landlord to refuse to return your security deposit? Or maybe they deducted way too much without justification. It's frustrating and stressful. Today's video is for every tenant in Kenya who's faced this issue. I'll walk you through the legal rights you have, what evidence you need, the steps you should take, and how the small claims court can help you get what you deserve. Let's start from the beginning. What exactly is a security deposit, and what does the law in Kenya say about it? A security deposit is money a tenant pays a landlord at the beginning of a tenancy, usually equivalent to 1 month's rent, but it can vary depending on the agreement. It acts as a financial safeguard. The idea is simple. If you damage the property, skip rent, or leave unpaid bills, the landlord can use part or all of that money to cover those costs. But here's the catch. Once you move out and there's no valid reason to keep it, the landlord must refund it in full. Now, in Kenya, there isn't one single security deposit act. Instead, the law is drawn from a mix of sources. Contract law under the Law of Contract Act, Cap 23. This means your lease or tenancy agreement is a legally binding contract. If it says you paid a deposit, then the landlord is legally obligated to refund it when the tenancy ends, unless there's a lawful reason not to. Landlord and Tenant, shops, hotels, and catering establishments, Act. While this mainly covers commercial spaces, it helps establish general landlord-tenant principles such as fairness and accountability. The Rent Restriction Act, for houses where rent is below a certain amount. This act also touches on landlord duties and tenant protection. Case law. Kenyan courts have developed strong precedents through judgments. A key example is Muhanda versus LP Holdings Limited, 2025, which confirmed that the Small Claims Court has jurisdiction to hear disputes involving refund of deposits. That's a big win for tenants because it means you can pursue refunds without long, expensive court battles. So, the law recognizes that a security deposit is not income for the landlord. It's trust money, held for safekeeping, not for spending. Legally, landlords should only deduct from it for outstanding rent, unpaid utility bills or service charges, verified damage to the property beyond normal wear and tear, for example, a broken window or missing fixtures. What they cannot do is arbitrarily hold the money just because. Deduct for things that are normal depreciation, like faded paint or worn-out curtains. Delay refund without giving valid reasons. Although Kenyan law doesn't set a strict nationwide timeline, most tenancy agreements require landlords to refund the deposit within 30 days after the tenant vacates, once inspection is done. If the landlord needs to deduct anything, they must provide a written breakdown, basically an itemized list of what's being charged and why. Without that transparency, withholding your deposit can be treated as unjust enrichment or breach of contract, both of which you can challenge in the small claims court. For example, let's say you were renting a 1-bedroom in Nakuru for KSH 15,000 a month and paid a 1-month deposit. When you move out, you've cleared rent, and the only issue is a tiny wall stain from a picture frame. That's normal wear and tear, not damage. The landlord isn't legally allowed to deduct your deposit for that. However, if you left with a broken sink or unpaid KPLC bill, the landlord could use a portion of your deposit for those verified expenses, provided they show receipts or quotes to support the deduction. So, in short, a security deposit is your money held in trust, not a landlord's bonus. Now that we know what a security deposit is and what the law says, let's flip the coin. Before you can demand your deposit back, you must have fulfilled your own obligations as a tenant. The law works both ways. You can only enforce your right if you've also done your part. Let's go through the key conditions, step by step. 1. A valid tenancy agreement. First things first, you need proof of the tenancy. That could be a written lease agreement, or even a verbal one backed by evidence like rent receipts, text messages, or MPESA records. A written agreement is best because it shows how much the deposit was, what it covers, when and how it should be refunded. Without such proof, you can still file a claim, but the case becomes harder. It turns into your word against the landlords. So, always insist on something written. even if it's just an email or text acknowledgement. 2. Proof of payment of the deposit. You also need clear proof that you actually paid the deposit. This could be an official receipt, a bank transfer or MPESA statement, a written acknowledgement from your landlord or agent. Without this, your claim will have no foundation. Remember, in court, it's not about what you say, it's about what you can prove. 3. Fulfillment of rental obligations. The next condition, and this one is huge, is that you've met all your tenancy obligations before leaving. That means paying all your rent up to the final day, clearing electricity, water, garbage, and service charge bills, giving proper notice before vacating, usually 30 days or whatever your lease states. If you leave suddenly or without notice, your landlord can argue you caused financial loss, and that can be a valid reason to deduct from your deposit. 4. Leaving the property in reasonable condition. Now, this is where most disputes start. The law expects you to leave the property in a reasonable condition, meaning normal wear and tear is fine, but damage is not. Normal wear and tear includes things like slightly faded paint, minor nail holes, light scuff marks on the floor. Damage, on the other hand, is broken window panes, missing door handles, burnt countertops. The key difference is whether the issue is a result of ordinary use or negligence. To protect yourself, take photos and videos both when you move in and when you move out. These visuals are powerful evidence if things go to court. 5. Document the property's condition. In fact, many tenants overlook this, yet it's one of the strongest defenses you can have. Do a move-in inspection and a move-out inspection, preferably with your landlord or agent present. Ask them to sign off on an inventory checklist or inspection form. If they refuse, take time-stamped photos or videos. Even short clips on your phone are enough to show the condition of the house. When you later demand your refund, you'll have proof that you didn't damage the property. 6. Formal demand for refund. Finally, before you rush to court, you must make a formal written demand to your landlord. This is often called a demand letter, and it's simply a polite but firm notice asking for your deposit refund. In the letter, you should state the date you vacated, confirm you've cleared all dues, attach copies of proof of payment and property photos, give a clear deadline, for example, kindly refund my deposit within 14 days. If the landlord doesn't respond or refuses, then you move to the next step, the small claims court. Why is this important? Because courts love to see that you tried to resolve the matter amicably before filing a case. So, what does the law actually say about landlords withholding security deposits in Kenya? A lot of tenants think landlords have the final say, but that's not true. The law is on your side if you understand where to look. In Kenya, there isn't one single act that directly governs security deposits. Instead, the issue is guided by a combination of laws, contract principles, and judicial precedents. Let's unpack them one by one. 1. Law of Contract Act, Cap 23. This is the foundation of every tenancy relationship. When you sign a lease or agree verbally with your landlord, that's a contract, legally binding under the Law of Contract Act. It means both parties have duties. You, as the tenant, must pay rent and keep the house in good shape. The landlord must respect your right to quiet possession and refund your deposit once your obligations are done. So, if your landlord keeps the deposit without reason, that's a breach of contract, and you can legally demand repayment. 2. Landlord and Tenant Act, Cap 301. Although this act mostly applies to commercial premises, Kenyan courts often rely on its principles to interpret fairness in residential tenancies, too. It emphasizes that tenancy relationships must be conducted in good faith, and landlords cannot impose unfair terms or exploit tenants. When a landlord withholds a deposit unfairly, they're essentially acting in bad faith, which violates this principle. 3. Rent Restriction Act, Cap 296. This one applies to low-cost housing, where rent doesn't exceed a certain threshold, currently around $2,500 monthly. It empowers tenants to challenge exploitative landlords in rent tribunals, including cases of unlawful withholding of deposits. So if your rent falls within that range, you can take your dispute to the rent tribunal, not necessarily court. But for most tenants today, the best avenue is the small claims court, fast, affordable, and straightforward. 4. The Small Claims Court (SCC) Act 2016. Here's where it gets interesting. The Small Claims Court. Established under the Small Claims Court Act 2016. This court handles simple civil and commercial disputes involving amounts up to 1 million shillings. Security deposit disputes fall squarely under this. Why? Because these cases are about money owed under a contract. The SCC is designed for speed. Every case should be heard and concluded within 60 days. You don't even need a lawyer. That's a big deal for tenants who can't afford lengthy, expensive high court cases. 5. Key judicial precedent. Muhanda vs. LP Holdings Limited, 2025. Now let's talk about one of the most important recent cases. Muhanda vs. LP Holdings Limited, 2025. In this case, a tenant took her landlord to court after the landlord refused to refund her deposit, even though she'd met all her obligations. The landlord argued that the matter didn't belong in the small claims court, but the High Court ruled that disputes over security deposits are indeed within the jurisdiction of the small claims court, because they involve a liquidated claim, that is, a specific, quantifiable amount of money. This ruling set a strong precedent confirming that tenants can file deposit refund cases in SCC. SCC decisions on such matters are enforceable just like any other court order. Landlords can't hide behind technicalities to delay repayment. In other words, your deposit case is valid in small claims court. 6. Other relevant principles from Kenyan courts. Apart from Muhanda, several other rulings have reinforced that a security deposit remains the tenant's money until proven otherwise. Landlords must justify every deduction with receipts, photos, or quotations. Unexplained withholding can amount to unjust enrichment, which is illegal under Kenyan contract law. Simply put, a landlord can't profit from your deposit. They're only holding it in trust. Now here's where things get interesting. When you ask for your deposit back, most landlords suddenly turn into professional debaters. They'll throw excuses left, right, and center, hoping you'll get frustrated and walk away. Let's break down the most common ones and how to legally counter each one like a pro. 1. You damage the house. This is the number one excuse. The landlord says you damaged something: walls, doors, sockets, paint, and therefore they must use your deposit to repair it. Here's the truth. The law allows them to deduct only for actual, proven damage, not normal wear and tear. Normal wear and tear includes things like slight discoloration of paint, loose curtain hooks, small nail holes. What counts as damages? Broken windows, burned countertops, missing fixtures. So, how do you counter it? Ask for proof of repairs, actual invoices or receipts. Show your move-out photos to prove you left the house in good shape. Remind them that deductions without proof are illegal under the landlord tenant law. 2. I used it to cover unpaid bills. Another common line. Your water or electricity bills weren't paid, so I used your deposit to cover them. Legally, that's only acceptable if they can prove those bills were truly unpaid. The correct process is present the actual bill statements, show that they're in your name or tied to your unit. Subtract only the verified amount. If they can't show proof, it's an empty claim. You can counter by showing your final utility payment receipts or a clearance letter from the service provider. 3. You didn't give notice before leaving. This one is legal only if your lease clearly required a notice, usually 30 days. If you left without notice, the landlord can legally keep 1 month's rent in place of that notice. But if you gave notice, or if they asked you to vacate, they can't use this excuse. To counter, keep a copy of your written notice or WhatsApp message showing the date you informed them. If they verbally agreed for you to leave, mention that in your written claim or court statement. 4. I haven't found a new tenant yet. Some landlords will say I can't refund your deposit until someone else rents the house. Wrong. The security deposit is not tied to the next tenant. It's tied to your tenancy. Once you move out, clear your bills, and hand over the keys, they're legally obligated to refund your deposit within a reasonable period, usually 14 to 30 days. If they delay beyond that, they're in breach of contract, and you can claim not just the deposit, but also interest and costs in court. 5. The agent or caretaker has your money. This one's sneaky, especially in apartment setups. You'll hear, I don't handle deposits. Talk to the caretaker or the agent. But here's the legal truth. The landlord remains responsible for your deposit, even if you paid through an agent. According to Kenyan tenancy law, the agent acts on behalf of the landlord. So, your claim should still be directed at the landlord, not the middleman. If you file in the small claims court, always list the landlord's name as the respondent, not the agent. 6. Will refund after repairs are done. This one sounds reasonable, but it's often a stalling tactic. The landlord says they'll refund after assessing and repairing the house, and then months go by. Legally, that's not allowed unless they have done actual repairs or they can prove those repairs were necessary and cost within your deposit. Otherwise, they're just holding your money unfairly, and that's what the court calls unjust enrichment. 7. You forfeited the deposit because you left early. If you break your lease midway, some landlords say you automatically lose your deposit. That's not entirely true. The law says a landlord can retain part of the deposit to cover losses caused by early termination, but they must prove those losses. Even the smartest tenants fall into these traps. Sometimes, it's not the landlord who's unfair. It's the tenant who unknowingly weakens their own case. So before you move out or even sign a new lease, make sure you're not making these costly mistakes. Mistake 1. No written lease agreement. This is by far the biggest mistake. Many tenants move into houses with just a verbal agreement, or a quick MPESA payment and a handshake. The problem, when things go wrong, there's nothing in writing to prove the terms, like how much the deposit was, or when it should be refunded. Without a written lease, it becomes your word against the landlord's. Mistake 2. Paying cash without a receipt. Another classic error, paying your deposit or rent in cash, and trusting the landlord to remember. In court, the burden of proof is on you. If you can't prove you paid, the law assumes you didn't. Always pay through a traceable channel, MPESA, bank transfer, or if you must pay cash, demand a signed receipt. Even a simple text saying received KSH 15,000 deposit, thanks, can save you thousands later. Mistake 3. Not documenting the house condition. This one destroys more deposit refund cases than anything else. Tenants move in, ignore the cracks, stains, or broken sockets. Then when they move out, the landlord blames them for everything. Always take photos and short videos when moving in and when moving out. Capture walls and ceilings, sinks, bathroom tiles, sockets, windows, and doors. Store those photos with timestamps. Your phone automatically records that. When disputes arise, those photos become your best legal shield. Mistake 4. Failing to give proper notice. Many tenants think they can just pack up and go. But legally, if your lease requires 30 days notice, you must give it, or risk losing part of your deposit. Even if you're on a month-to-month arrangement, always give written notice. A simple WhatsApp message or email counts, as long as it's clear and dated. If you don't give notice, the landlord can argue they lost rent, and that's a legitimate deduction. Mistake 5. Arguing emotionally instead of writing formally. When conflict starts, many tenants rush to argue over the phone or text angrily. That doesn't help. In fact, it often makes things worse. Courts prefer formal written communication, not emotional exchanges. Instead of sending 10 angry texts, send one calm, written message or email stating, "I have vacated and cleared all bills. Kindly refund my deposit of KSH amount within 14 days. It's clear, professional, and legally sound. Mistake 6. Handing over keys without documentation. Some tenants leave keys with the caretaker or neighbor, without any written acknowledgement. Later, the landlord claims you never officially vacated, and keeps the deposit claiming rent is still running. Always ensure a formal handover, ideally in person with the landlord or agent. Ask for a short note or message saying, "Received keys on date, house inspected and vacated." That one sentence protects you from fake claims. Mistake 7. Ignoring small deductions. Some landlords deduct small amounts, maybe KSH 1,000 or 2,000, hoping you'll ignore it. But remember, that's your money. Always ask for a breakdown of deductions. If they can't justify it with receipts, you can challenge it. The small claims court doesn't care about the amount, it cares about the principle. Mistake 8. Not following up or filing a claim. This is the final and most painful mistake, doing nothing. Many tenants walk away because they think it's not worth the effort. But the law gives you a simple, affordable route, small claims court. You don't need a lawyer, and you can win in as little as 60 days. Even if your deposit was only KSH 10,000, remember, that's still your hard-earned money. Don't just let it go. Now that you know what the law says, what exactly can you do if your landlord refuses to refund your deposit? Don't panic. Don't argue endlessly. There's a clear legal way to handle it. Here's a step-by-step guide to getting your money back. Step 1. Gather your evidence. Before taking any action, gather all documents related to your tenancy. You'll need proof to show that you paid a security deposit, fulfilled your part of the contract, and the landlord is unlawfully withholding your refund. Collect items such as your tenancy agreement or lease, deposit payment receipt or MPSA message, rent payment records, handover inspection photos before and after, and any messages between you and the landlord. This evidence will form the backbone of your case. Step 2. Make a formal refund request. Start by sending a formal written request, either through email, WhatsApp, or even a short letter. Be polite but firm. Mention that you've met all obligations and request a refund within a specific period, say 7 to 14 days. This is important because courts want to see that you tried to resolve the issue amicably first. Step 3. Document the landlord's response or silence. If your landlord responds, keep every message. If they don't respond, record that too. It strengthens your case. In law, silence can sometimes be interpreted as refusal. This step shows you acted in good faith, but the landlord didn't. Step 4. Send a demand letter. If the landlord ignores your request, the next move is a demand letter. You can write it yourself or get help from a legal aid service, paralegal, or advocate. The letter should state the facts clearly, mention the specific amount owed, give a final deadline, for example 7 days. Warn that you'll file a small claims court case if not refunded. Step 5. File a claim in the Small Claims Court, SCC. If the landlord still doesn't act, it's time to file a claim. The Small Claims Court handles cases up to 1 million, and deposit refunds fit perfectly. Here's how it works. 1. Visit the nearest SCC registry, found in major towns like Nairobi, Milimani, Mombasa, Kisumu, Eldoret, Nakuru, Kakamega, etc. 2. Fill out a statement of claim form. 3. Attach your evidence, receipts, photos, letters, messages. 4. Pay a small filing fee, usually around 500, 1,000. The court will summon your landlord to appear. No lawyer is required. You can represent yourself. The entire case should be completed within 60 days. Step 6. Court hearing and judgment. During the hearing, the magistrate will ask both sides to present their evidence. You'll need to show proof of deposit payment and prove you didn't damage the property or breach the lease. The landlord, on the other hand, must justify any deductions with repair receipts or inspection reports. If the court finds their deductions unfair or unsupported, it will order a refund, often with interest and costs. Step 7. Enforce the judgment if needed. Most landlords comply once judgment is issued, but if not, the court can enforce payment. Options include garnishing the landlord's bank account, attaching their property, reporting non-compliance to enforcement officers. The key is, you will get your money back one way or another. Before we wrap up, let's make sure you never forget the golden rule of protecting your deposit. It's simple, powerful, and easy to remember. I call it the SMART rule. If you follow these 5 steps, you'll almost never lose your security deposit. And if you ever do, you'll have such strong evidence that getting it back, even in court, will be quick and stress-free. Save all documents and receipts. The very first and most important rule, save everything. Every payment you make, rent, deposit, or repair, keep the proof. That means M-Pesa messages, bank transfer slips, or cash receipts, your tenancy agreement and any letters, WhatsApp chats, or emails between you and your landlord. Don't delete anything. Don't rely on memory. Why? Because in court, your story means little without proof. Judges rely on documents, not emotions. Think of it like this. Your phone gallery and email are your strongest lawyers. Make written communication. Second, always communicate in writing. Phone calls are forgotten, but messages can be printed and presented in court. When you give notice, follow up with a text or email or when you discuss repairs or deposit refunds. Send a short message confirming what was agreed. That single message can be worth more than any lawyer's argument. And if the landlord later changes their story, your written record tells the truth. Arrange joint inspections. Don't just move out quietly and hand over the keys. Ask your landlord or agent to walk through the house with you. Together, check for damage, record everything, and take photos. If possible, write a short note confirming the condition. Something as simple as, "House inspected on the 1st of June, no major damage found." This stops surprises later like, "You broke the sink," or "You left the walls dirty." A short inspection takes 10 minutes and can save you months of stress. Respect notice periods. Even if you're frustrated, don't move out overnight. Most leases require 30 days written notice. And if you skip that, your landlord can legally withhold your deposit. So, check your agreement for notice terms. Give your notice in writing. And keep a copy. Also mention your expected move-out date. For example, "Dear Mr. Oceano, this is to give 1 month notice of my intention to vacate your apartment by the 31st of May. Simple, clear, and legally safe. That one message protects your deposit and your reputation as a good tenant. Take photos before and after. When you move in, capture everything: walls, doors, sockets, tiles, bathroom, and kitchen. When you move out, do it again. That way, if the landlord claims you caused damage, you'll have visual proof of how you left it. Bonus tip: email those photos to yourself or store them in Google Drive so they have timestamps. Courts love time-stamped evidence. It proves exactly when photos were taken. Do these 5 things, and your chances of losing a deposit are near zero. Even better, if your landlord plays hardball, you'll walk into the small claims court fully armed with evidence. Because being smart isn't just about avoiding conflict, it's about being ready for anything.